You know, looking at this Little League park brings back childhood memories for me. Since my dad was an athletic director, I spent many hours helping him take care of these fields. Well, now you should have gotten day one out of the way. You've met me, you've met my team, you got the 9 steps to divorce, and today we're going to talk about the most important thing in a family law case, and that's child custody. So the first word that we need to talk about is status quo. Once you leave the marital residence, the visitation schedule that goes into effect becomes the status quo. Each parent has an equal right of access to the children, and that's why it's important to seek a court order early so that one can't hoard or keep the children away from the other parent. If you're the wife, for example, and you leave the marital residence and your husband starts visiting with the kids every other weekend, then that becomes the status quo. At a temporary custody hearing, the judge will maintain the status quo unless there's emergency grounds to alter that arrangement. An emergency like threatening to leave the state with the children, threatening to harm the children. If there's no emergency, the status quo will remain in effect until we have a permanent custody hearing. There's 2 ways to resolve a child custody dispute. You can enter into a separation agreement and property settlement that's got terms regarding child custody in it, or you can obtain a court order. I'm going to tell you why you need to obtain a court order. If your spouse gets mad with you and he or she is supposed to bring the children back on Friday and they don't, then if all you have is a contract, you've got to file a lawsuit, and you've got to ask the court for specific performance of that contract. However, if you've got a court order, you can file a motion for contempt, and the court has in its discretion the power to put your spouse in jail for non-compliance with a court order, to order that your attorney fees be paid, and other legal remedies. One thing I know you don't want to ever think about is your child being kidnapped. Believe me, it can happen. And I've dealt with parents who have had their children taken by the other spouse, even to another state. If all you have is that separation agreement, you're at a disadvantage. You have to go into court, seek specific performance, and seek an emergency custody order. Whereas if you get a court order to begin with, you can actually have that parent charged with felony parental kidnapping and seek the help of the FBI, who will help to return your child. You need a court order. Okay, so with respect to child custody, what's really important? The first thing the judge has to consider is whether each parent is a fit parent and whether they've acted inconsistent with their constitutionally protected status as the child's natural parent. Well, that's a long phrase, but basically what the judge is looking for is there any reason that this individual shouldn't have some form of custody? If they're a drug addict or have serious mental health issues, or are an alcoholic, or they've abused the child in some way or neglected the child in some way, the judge might consider them to be unfit or have acted inconsistent. And if that's the case, the parent who's fit will be the parent that has custody. Now, if both parents are fit, and they usually are, because it's a hard standard to say they're unfit. But if both parents are fit, then the question is, what's in the child's best interest? And with respect to that question, any evidence can be introduced, and everything is relevant. So what should you do before you separate? Well, you need to start collecting information about the children. If they're in school, we're going to need their grades. We're going to need their attendance records. We're going to need their medical records to show who provided medical care the majority of the time. Because if both parents are fit, one of the things the judge generally looks for is which parent has played the most active role in their day-to-day life. So I want to be able to go into court and say, My client's the one that's taken them to 75% of all their doctor appointments. My client's the one that takes them to childcare. My client's the one that picks them up from school. My client's the one that goes to all the parent-teacher conferences. So any evidence that you have that proves that you're actively involved in your child's life, that's the evidence that we're going to need. There's a number of ways that we can get that evidence. We can use private investigators as we need to. We can ask the court to appoint a guardian ad litem. Usually don't do that here in eastern North Carolina, but you might do it under certain circumstances. And the guardian ad litem then represents the child and can express the child's interest in court. Now, clients often ask me, at what age can my child make the decision to go live with the other parent? And I answer them, no age. We don't want to empower the child to believe that they're the ones that can make this decision. Now, it's true, a child can express their interest or their opinion as early as, say, age 8 or 9 or 10. But we shouldn't make them believe that they're the decision maker. And in fact, when the judge meets with them, the judge will usually tell them, you're not making the decision, but I do want to hear what you have to say, and I will take it into consideration. So, mental health professionals can give us evidence, guardian ad litems, private investigators, neighbors, pastors, friends, anyone that has seen you as a parent and knows your parenting abilities and has seen you interact with your child. We often call teachers to the witness stand and others. So one of the things you can do before you separate is collect that evidence, and it's in our 9 steps to divorce. We've listed the things that we think you need to collect. But you can also start making a list of who you think would be a good witness. Another thing we do to help our clients, and I've posted this link to the right of this video, is we're going to let you download a child custody notebook. These are the questions that we want you to answer if we represent you, so that we go into court, we can present the whole picture about your relationship with your child. So it asks for information about Boy Scouts and Girl Scouts and other extracurricular activities that your child's been involved in. This is one size fits none. We know that, okay? So you're going to have to make it work for you. If you're not married to the other side, change your spouse to the other parent and answer the questions. This was developed by Charles Rice, my partner, because when he was a chief district court judge hearing child custody cases, he often would walk on Wrightsville Beach for hours trying to make a decision about what was in the best interest of that child. And it was tough for him to make the decision, because he's told me that often the attorneys presented a case about what a bad parent mama is, and mama presented a bad case for dad. But he didn't learn anything about the child. He didn't learn about their diet, their nutritional needs, their emotional needs, their mental health needs, how they were doing in school. So we've designed this notebook to make sure that when we try a custody case, our judges are going to know about that child. So there's a lot of other things we could talk about in the whole area of child custody. Grandparents' rights, the complaint process, when temporary custody is heard. And I don't have enough time to go into all of that in detail, but I have posted some links to the left and the right of this video, and you should download that information and read it. Tomorrow, we're going to talk about the overview of child support, what you need to know, and I'll see you tomorrow.